Welcome to our case studies webinar for enhanced estate planning. Hello. Back in January, a young woman named Grace, with a bright future ahead of her, tragically lost her life. She was the college lab partner of my niece's husband. She had flown home to Wichita for her grandfather's funeral and was returning to school when disaster struck. She was an outstanding engineering student, and her flight was supposed to land in Washington, but on January 29th, 2025, that plane tragically collided with an Army Black Hawk helicopter. Just this week, I spoke with someone who were close friends with the parents of the Black Hawk pilot. Losing a loved one is devastating enough, but in the midst of grief, families are also left to navigate the overwhelming process of managing accounts, assets, and legal documents. If you don't have a plan in place, the state has one for you, and it may not be what you would have wanted. How much does it cost to protect your loved ones from that burden? A living trust typically runs between $1,500 and $2,500 or more. A pour-over will cost around $500. Financial and medical power of attorney documents are usually $150 each, but we cover those costs for you. Why do we do this? Because we both know you need it. We know it feels overwhelming, or that no one likes talking about death. Life gets busy, and it's easy to put off, but we've got your back. My goal is to make this process simple, stress-free, and thorough. From the moment you watch this video to the final step of transferring the deed of your home into the trust, my firm is here to guide you. I want you to be so impressed with our service that you share it with your family, friends, and coworkers, because they need this too. Let's get started. Case Study 1. Mrs. Darnold. This is the reason I have become so passionate about enhanced planning, as I am a major part in this story. Mrs. Darnold was the mom of a good friend of mine. One day she asked me to be the executor of her small estate. I reluctantly agreed, and we got to work. She didn't want to hire an estate attorney and thought we could write a will and 5 wishes on LegalZoom, which we did. Mrs. Darnold was very ill and knew her time was soon. In the meantime, I moved to California and got stuck there due to COVID. I told Mrs. Darnold it would be wise if she found somebody else, because if something happened, I would not be able to effectively manage her estate, as I couldn't easily get back. She agreed. When I was able to, I moved back to Colorado. She passed away shortly after. I went to her house the following day and found out I was still listed as executor. It was just a house with a mortgage, an annuity, her car, and furniture. We put the house up for sale. She indicated in her 5 wishes she wanted one son to get the bedroom set and her grandson to get the car. The annuity is a contract and always supersedes trusts and wills, so the only thing I had to worry about was the house with a mortgage. Mistakes made. There were many. First, a will still goes through probate. I didn't know this at the time. While we set her granddaughter as financial power of attorney, which was good, as she could access the bank account and pay the mortgage, we didn't know or expect probate to take as long as it did. Second, we didn't add a clause that anyone who contested will would get $0. What we should have done is set up a trust and change the deed of her house to be in the trust's name. Had she agreed to this, maybe there wouldn't have been $100,000 in lawyer fees, executor fees, storage fees, court fees, and maybe the kids would still communicate with each other. Lesson learned: if you have assets and you don't want an impartial court saying where things go, set up a trust and make sure you put your assets in the trust, as a trust without assets is just a piece of paper. Case Study 2. Mrs. Jones. Mr. Jones passed away. This couple had separate bank accounts. Mr. Jones passed seat without having a trust or a will, and especially in this case, a financial power of attorney. His bank account was frozen. Mrs. Jones couldn't access the account for months and had no way to pay immediate bills. Case Study 3. The Dietz family. In this case, the Dietz family are setting up a trust. One fantastic thing they're doing is gifting while they are still alive. Mr. and Mrs. Dietz are giving children and grandchildren both one-time payments and yearly payments in order to help out family and lower wealth. You can give yearly payments up to a certain amount. You can also give larger payments as you have a lifetime max you can give away. Please know the rules and fill out the right forms so the IRS doesn't come knocking on your door. Case Study 4. The Timber family. I call these people the Timber family, and you will see why. Grandpa Timber passed away. Him and his wife owned thousands of acres, which they leased to a logging company yearly. Then Grandma Timber passed away. She had nothing, not a will, trust, or power of attorney, nothing. So everything went to probate. The IRS doesn't care. They wanted their cut and sent a bill to the family for taxes due in 60 days. $950,000. The family doesn't have that kind of money, and still a year or more of probate left. The wonderful logging company felt bad, so they offered to buy the land for $950,000. The family got nothing. By the way, in Case Study 1, half of the kids' inheritance went to fees. I had to get a lawyer and eventually step aside. And not only do the kids not speak, but neither do I with my friend. What should have been a seamless transition took a year and a massive headache for everyone to finish. There are 3 reasons people don't get a trust, even though it makes life so much easier for their loved ones. 1, they don't like to discuss dying. 2, time. And 3, money. Pathfinder helps guide you through the process, including establishing the trust. First, you have to decide who and what. Secondly, get everything notarized and assets deposited into your trust. Third, changing your deed's name to the trust name. We will also guide you through this process on Rocket Lawyer. Pathfinder can issue the power of attorney and payable on death at no cost to you. Pathfinder can assist you in establishing your trust, normally $3,000 to $5,000 for only $100, shipping fee, and roughly 2 hours of work. You will no longer have anything holding you back. Case Study 5. The Case of Dale Earnhardt Sr. Ownership Structures and Control Conflicts. Dale Earnhardt Sr. was a successful NASCAR driver with considerable wealth and a business empire centered on racing. However, his untimely death in 2001 exposed weaknesses in his estate planning, particularly around the ownership of his business interests. One major source of conflict involved his son, Dale Earnhardt Jr., and Earnhardt Sr.'s third wife, Teresa Earnhardt. The dispute was centered on control of Earnhardt Sr.'s racing empire, including rights to his name, likeness, and related assets. Earnhardt Sr.'s estate, including his business holdings, was not clearly structured to indicate who would inherit what, which led to a power struggle between family members. Teresa Earnhardt had legal control over many of the business aspects, while Dale Earnhardt Jr. sought to establish his own legacy in racing. These tensions likely arose because there was no clear succession plan or structure that defined who would control the business interests after Earnhardt Sr.'s death. Probate and the need to avoid public conflict. Had Earnhardt Sr.'s ownership structures been more clearly defined through the use of trusts, joint ownership arrangements, or specific business succession plans, his family might have been able to avoid the public and protracted legal disputes that ensued. These disputes played out not just over the business itself, but also over personal aspects, like the use of his name and image. Lessons learned. The key takeaway from Dale Earnhardt Sr.'s estate case is that proper ownership and transfer strategies are crucial in preventing family disputes. Families with considerable wealth, especially those involving businesses, need clear estate planning, including trusts, wills, and business succession plans that leave no room for interpretation. Defined ownership structures to clarify who will control or benefit from specific assets. Transparency, particularly in blended families, so that all parties are aware of their roles and rights after the estate holder's passing. This case underscores how estate planning failures, particularly around ownership structures, can lead to painful and public disputes, overshadowing the legacy of someone as iconic as Dale Earnhardt Sr. Case Study 6. Adding directives in a trust is a powerful tool to ensure that your legacy and wealth are protected and properly managed for future generations. Lisa Marie Presley's mismanaged inheritance illustrates why it is crucial to incorporate clear instructions, reliable trustees, and robust oversight mechanisms within an estate plan. 1. Preserve long-term control over key assets. Why? In Lisa Marie's case, selling 85% of Elvis Presley Enterprises, EPE, generated short-term financial relief, but cost her long-term control and revenue from her father's legacy. Including directives that prohibit or limit the sale of key assets, ensures that these holdings continue to generate wealth and remain within the family. How? Specify in the trust that essential assets, such as business interests, real estate, or intellectual property, cannot be sold without the approval of multiple trustees or a set number of family members. You could also direct that income from these assets be reinvested or preserved for future generations. Conclusion. Lisa Marie Presley's cautionary tale shows how mismanaged inheritance and poor financial planning can quickly erode even vast fortunes. By incorporating clear directives into a trust, such as preserving key assets, promoting responsible financial management, controlling spending, appointing skilled trustees, and implementing oversight, you can ensure that your legacy is protected and continues to benefit future generations. Case Study 7. Prince Rogers Nelson, the legendary musician and artist, passed away unexpectedly on April 21st, 2016, at the age of 57. His death not only shocked the world, but also revealed that Prince had died intestate, meaning without a legally valid will. This lack of a clear estate plan resulted in years of legal disputes, a prolonged probate process, and significant financial and emotional burdens for his family. Legal costs and delays. The lengthy probate process, combined with legal disputes over the estate, racked up significant costs. Attorneys and estate administrators charged millions of dollars in fees over the years it took to settle the estate. By mid-2022, the legal fees had reportedly exceeded $10 million, further depleting the estate's value. The estate was officially settled in 2022, 6 years after Prince's death. The delays in resolving the estate meant that Prince's heirs had to wait years to receive their inheritance. Even after the settlement, ongoing management of his intellectual property and music catalog will continue to require legal oversight and negotiations. Lessons from Prince's estate. Importance of a will. Prince's estate highlights the importance of having a will or other estate planning documents in place. Without clear instructions, even an estate of modest value can become bogged down in legal disputes and probate, while larger estates face greater financial risks. Avoiding probate. Proper estate planning tools, such as trusts, can help avoid probate and ensure that assets are distributed according to the decedent's wishes. If Prince had set up a revocable trust, his assets could have been managed and distributed privately without the need for public probate proceedings. Case Study 8. Michael Jackson's untimely death in 2009 led to one of the most publicized probate battles in history, despite his considerable wealth and fame. Estate planning gaps. While Jackson had a trust in place, not all of his assets were properly transferred into the trust, which subjected portions of his estate to probate. The probate process was lengthy, expensive, and brought intense public scrutiny. Tax controversies. Jackson's estate was initially valued at $7 million by his executors, but the IRS disagreed and valued it at over $1 billion, leading to a significant legal battle. The estate ultimately settled with the IRS for $482 million in back taxes and penalties. Lesson learned: even with a trust, it's critical to ensure that all assets are correctly titled in the trust's name. Jackson's case highlights the importance of thorough and continuous review of estate plans to avoid costly tax disputes and probate delays. We put these celebrities in here, not because they are the only ones who need a trust, but because there is truth to all of their stories. The majority of us will never be a champion NASCAR driver, or related to Elvis or a worldwide superstar like Prince and Michael Jackson. By the way, did you know that almost every year Michael Jackson is the highest paid celebrity, dead and alive? And if you have assets and or beneficiaries, then you need a trust. If you are retired and worried about your legacy, you need a trust. If you are still currently working, but the thought of the state determining your legacy or guardianship of your children is problematic for you, then you definitely need a trust. If you are a young family and need to make sure if anything happens to you or your spouse that the kids go to someone you trust and may have financial help in place for when they will need it later in their lives, then you certainly need a trust. If you have a checking account, you need a POD, and if you are over 18 at the very least, you need a POA in place. Possible scenarios: subject and spouse die with or without a will. Estate goes to probate. They live in Fairbanks where it's 40 below zero, and you have to pay $1,000 a month to heat home and plug in car. Will the court-appointed executor take care of all this before pipes break, engine block freezes, and probate is finally finished? Lesson learned: no matter what the scenario, your wishes are best abided by if it is a trust. In most states, a will takes 12 months to go through probate. Same scenario, but any location. There is a mortgage on property. The executor may have to sell assets to pay mortgage for a year. Not at all what client intended. 3. Pour over will. One thing you do not want to include in your trust is your vehicle. Instead, you put it in a pour over will. This is for everything not included in the trust. The reason for this is you do not want the trust vulnerable to a lawsuit if there is a tragic accident you cause. A pour-over will is a type of will used in conjunction with a living trust. It ensures that any assets not transferred to the trust during the testator's lifetime pour over into the trust upon death, keeping the assets aligned with the trust's terms. A pour-over will complements the living trust by ensuring any assets unintentionally left out of the trust. During life, they are still managed according to the trust's terms. Let's recap. Advantage of trust over will. A trust can be used to avoid probate, can provide creditor protection for the inheritance you leave to beneficiaries, can protect governmental benefits for a person with disabilities, can reduce estate taxes, and can administer assets for minor beneficiaries without court intervention. A will cannot do any of these. Remember, changing a house deed name to your trust's name is on average about $50 at your county's office. Advantage of will over nothing, control over. Asset distribution. A will allows you to specify who receives your assets and in what amounts. Appointing a guardian. If you have minor children, a will lets you designate a guardian to care for them. Minimizing family disputes. A clear will can help prevent conflicts among family members. Simplifies the probate process. Although having a will doesn't avoid probate, it often makes the process smoother and faster. Tax benefits and estate planning. A well-structured will, especially with advice from an estate planner, can help minimize estate taxes or other financial burdens. Disadvantage of nothing. You leave all decisions up to impartial court.